Chicago, 2011. A cop is murdered. Police and prosecutors swear they have the trigger man. He swears he didn't do it. How far will each side go to prove they're right?
Like it's just one bombshell after another, where you're like, what?
The story of a PlayStation, a brain-eating amoeba, and the relentless pursuit of justice. Off Duty, out now. Listen wherever you get your podcasts.
This message comes from Jackson. Taxes aren't something you can only think about once a year. With investments, planning for tax day is year-round. Fortunately, Jackson offers tax-efficient products. Visit jackson.com for more information on how our products can make your tax bill a little bit less painful. Jackson is short for Jackson Financial Incorporated, Jackson National Life Insurance Company, Lansing, Michigan, and Jackson National Life Insurance Company of New York, Purchase, New York.
Howdy, howdy, ho, and welcome to Fantasy Fan Fellas. I'm Hayden, producer of the Fantasy Fangirls podcast and your resident lover of all things Sanderson.
And I'm Steven, your bookish internet goofball, but you can call me the Smash Daddy.
And we are currently deep diving Brandon Sanderson's fantasy epic, Mistborn. But here's the catch. Steven here has not read Mistborn before.
That's right, hey. So each week, you'll get my unfiltered, raw reactions to every single chapter.
And along the way, we'll do character deep dives, magic explainers, and Steven will even try to guess what's next. Spoiler alert, he'll be wrong.
Newsflash, I'm never wrong. Episodes come out every Wednesday, and you can find Fantasy Fan Fellas wherever you get your podcasts.
Hello, everyone, and welcome back to the Psych Legal Podcast. This is a podcast where we talk about popular culture through the lens of an attorney and a therapist. I'm Tess Brigham. I'm the therapist.
And I'm Brooke Brigham. I'm the attorney.
And we have a very special guest joining us today. This is Dr. Ashley Scolaro, PhD. She is a doctor of cognitive neuroscience, and she is also a professor at a small liberal arts college as well. Hello, Ashley. Thank you, Dr. Scolaro, to say.
Call me Ashley.
If I had a PhD, I'd make everyone call me doctor. I don't care. Because I've witnessed many people go through it, and it's a lot. So you deserve it. You deserve it. But thank you so much. Ashley has been following. Today we are talking about the Karen Read trial, specifically the second trial. So we have covered the Karen Read trial before. We're not going to give a whole synopsis. My guess is that if you're here listening to us, you know what's going on with Karen Read. But, there was a trial last year. It was a hung jury. This year, jury selection started on April 1st. They had an 18-person jury set by April 15th, 9 men, 9 women. The opening statements started April 22nd, and then June 13th were the end of the closing statements and jury instructions. So as we're recording this, there is no verdict yet. So we are going to talk at the end a little bit about what our predictions are. But Ashley has been following this trial very closely, so she really knows what's going on. I have been following the trial on TikTok, which is another thing within itself. So I know a lot, but not as well as Ashley. And Brooke, actually, we covered, as I mentioned, we covered the first case, but Brooke hasn't been following the second case at all, the second trial. So I think this will be very interesting to hear her takes, because her takes are all going to be very fresh and new. So
yeah, and also Ashley has been watching the trial every day.
Yes.
Correct. And she has, we have gavel to gavel coverage here, and she is preparing, notes for one of her courses, that she's going to use, and using this case to teach her students. And so what Ashley, maybe just really quickly, Ashley is a listener of ours, and she contacted us, and we met her and talked to her and found out she was a wealth of information.
Yes.
For this type of thing. She's maybe you can tell us a little bit about the kind of courses that you teach, and what you're going to do with this data from the Karen Read trial, and just kind of what are your specialties? What do you focus on?
Sure. Yeah. Thanks for having me on. I'm enjoying talking to you already. So my area of expertise in cognitive neuroscience is in memory, forensic and legal psychology concepts like eyewitness reliability, even how how juries and judges make decisions, so some decision-making stuff there, and how people process information like physical evidence, so how people make decisions in a courtroom context around that. And I also studied conspiracy theory, which isn't relevant necessarily to, I guess, kind of relevant to parts of this case, possibly. But the course I taught this spring that I was already, was when the trial started April 1st, we were near the end of the course, was forensic neuroscience. And we were talking at that time about judges as gatekeepers for scientific evidence. And that's when the motions in limine for this trial came out. So it like overlaid perfectly with what we were already talking about. So it was a great way for my students to apply what we're learning to what was happening live. And then in the fall, I'm teaching a course that's for second year students. It's really about how to create a more just society, and lots of different faculty teach it with a topic. And the topic I picked was the Innocence Project, or criminal justice reform in general. So there's concepts in this case, not saying Karen Read is necessarily innocent, but thinking about the criminal justice system as a whole, there's lots of insights that students can take from this trial and apply in that class.
Mm-hmm.
Wow, great. So we have a lot to talk about.
Yes.
So we're going to kind of take this like topic by topic and just keep talking.
This is it's an elephant of a case. So It's like, how do you eat an elephant bite by bite?
Yes.
Chew by chew here.
Mm-hmm.
All right. So let's start with, are we going to start with the forensics? Because this is the stuff that I think it's very easy to get into the weeds about. But, and let's start with the car. And with the car, there was a big battle of the experts. So Ashley, could you talk a little bit about sort of like ARCA versus Aperture and the who testified and all that good stuff?
Sure. So Aperture was hired by the Commonwealth to come in and do accident reconstruction and analysis of the infotainment system. So the part of the car that stores, in fancy cars, right, that stores information about backups, collisions, if you have one. Anytime you put your brake on really fast, or you step on the gas really fast, it apparently timestamps, things like that. So Aperture was called by the Commonwealth, and they had two people testifying from them. One was Dr. Welcher, who did a controversial accident reconstruction with paint and Lexus that was just like Karen Read's Lexus, trying to show where the John O'Keefe's arm might have made contact with the Lexus. But they weren't able to rule out that they couldn't say for certain that a collision happened in their testimony. And the second one was Shannon Burgess, who actually testified before Welcher. But Shannon Burgess is a character. If you follow the second trial, you might have heard of him because he falsified information on his CV. They found at least 5 CVs that he has inaccurate information about a bachelor's degree he might have, but doesn't have. His LinkedIn profile has one that I think their university doesn't even have a major in that area.
Yeah, it's like a teenager made up. I have a degree in math and auto mechanic engineering. I mean, it really was one of those things like who has this? It was 2 big things that he mushed together. My question about him that I could never understand was, why didn't the prosecution vet this? Like, did they ever, I guess we have no idea why they just allowed this guy to testify now twice without ever doing any background on him at all.
I don't know. I know that they pulled his stuff down from the website within 72 hours. You couldn't hyperlink to his LinkedIn page. That came out because I think he testified on a Friday and then a Monday. I don't know, though. Sorry, I interrupted you, bro.
Oh, I was just because, I don't know. It seems to happen a lot. So I don't know. I don't really know how one goes about falsifying a resume, but it's just, I don't know. Did they call anyone to verify, or did they just take his word for it? I don't know.
I mean, because all this stuff they figured out, the defense figured out pretty easily because they just went on LinkedIn.
Right.
So it's a little bit, because it was revealed that he has been, one of the big things was whether or not he even has a bachelor's degree. And they basically found out that he had been basically working on this bachelor's degree for 17 years.
Mm.
So for a while, I think he would say he was currently working on it. And then I think at some point he just stopped saying he was working on it and kind of just omitted it and just sort of made it so that he had gotten the degree. I mean, it's bad. It's really, really bad.
Yeah. Wouldn't you think that the Commonwealth would call up someone at MIT and say, hey, give us a recommendation for, whatever. Like, where do they even find these people? I don't know. Strange.
Yeah.
Well, they tried, and they tried to kind of, Hank Brennan tried to, after Shannon Burgess was impeached, obviously, with these falsified CVs, Hank Brennan tried to make it like, everybody makes mistakes, right? Like there could be errors, but if I submitted a CV to my institution and said something, I could be fired for something like that. And I have tenure at an institution. Like that is a huge deal to lie about a degree that I worry about, like a publication that I have that it's published or it's, in review. Like I'm worried about that getting updated. So they tried to make it seem like it's no big deal, but I don't know what your all's perspective is, but mine is that is a huge deal. I don't think you can trust testimony.
No, it's lying. It's lying.
No. If you're willing to lie and half lie and kind of sort of lie about your experience and what you've been doing, then I cannot trust one thing that you're going to say to me at all. So he was a terrible witness, did not help their case at all. And then they bring on this guy Welcher, who was so arrogant. So, I mean, his arrogance and his smugness. And it turns out that he spent, they found out that the Commonwealth they paid Aperture a bill of about $400,000. And one of the things that Welcher bought was a Lexus. One of the things that I find fascinating is, imagine if her car was like a 1985 Toyota Tercel. Would this be good for her or not so good for her? Right? Is it a good thing that we have all this data? Because that's the one thing that stood out to me was like, wow, we can figure anything out on these cars now, right? Like that's pretty amazing. Between the phone technology and the car technology, it's pretty amazing. But anyway, Welcher bought a new Lexus. He did what Ashley was talking about, this. And I had watched the video many times and I was very confused by this test, because basically the prosecution, their argument is she backed up, she reversed and hit him. And purposefully. And, that they have to explain his arm. And we're going to, they have to explain the cuts and the, all that on his arm. And so Welcher's argument was, well, if John was behind the thing and his arm hit the tail lights and he used blue paint, he put paint on the back, and then he shows this car going into his hand and all this blue paint coming. And it's a little bit like, but how do you then explain these jagged scratches and marks, right? You just have blue paint
under his clothes.
Yeah.
Yeah. The paint, I mean, if it was, how did his shirt and his jacket or whatever he was wearing, how did that all come off? And
but Lexus was going 2 miles an hour in this recreation. And as the defense pointed out, like, you're assuming which hand he's holding a glass in versus the phone. You're assuming what angle. It only works if his arm is at a specific angle and if it's a side swipe. And if you were to hit your arm only at 24 miles an hour, wouldn't that break your arm? And Welcher said there was no medical examiner evidence or x-rays, which turns out that there were, and that came up later in the defense's case.
But and so again, you're paying these people a lot of money for their expertise, and they're lying. One person lying to you, and the other guy is just I mean, he's just making stuff up as he goes and cashing checks. That's what it feels like. That's what it's felt like to me. Versus ARCA. So let's talk about ARCA. And if you follow TikTok like I do, the ARCA boys are these, like, they're the, what do they call them? The zaddies. The, what are these guys known for? It's Dr. Daniel Wolf and Andrew Rensselaer.
Mm-hmm.
They're both reconstruction zaddies or what?
God.
I'm not on TikTok. I'm an elder millennial. I don't do TikTok. So.
Oh no, I'm older than you.
Yeah.
I have zero
age. TikTok knows no age.
Yeah.
So
I guess, between, I guess, I don't know, maybe I'm married too long, between Gavin Newsom zaddy stuff and these guys, I'm just fascinated. But so yeah, let's talk about ARCA.
Yeah. So ARCA was, so after the first trial that ended in a mistrial, the FBI opened an investigation of public corruption at the Canton Police Department to look into Michael Proctor and the investigation as a whole. The FBI hired ARCA as an independent company to determine whether or not there was a collision that caused the death of John O'Keefe. So really just trying to be as non-biased as you can when you're hired by the FBI, I suppose. That case was closed in January 2025 with the new presidential administration. They cut a lot of public corruption cases in the FBI, and this was one of them that got cut and eliminated. But they still had the documents, and so and their reconstruction, and that they're a very reputable firm. The military uses them for a lot of things, and so do sports leagues, including the National Hockey League. They use them for reconstruction, biomechanical things as well. And they testified that if there was a collision, there'd be broken bones, which there were no broken bones, and that there would be extensive damage to the Lexus from the body hitting it, which I live in Iowa. I live in snowy conditions. We have deer and other animal running everywhere. Like, it doesn't take them running very fast at your car to do a lot of damage, and they don't necessarily weigh the same amount that John O'Keefe is weighing. So that lined up just in my mind with what I was thinking, but that's really what ARCA brought to the table. I think that's.
And then obviously there was a lot of, was Hank Brennan pushing back on allowing ARCA to testify?
Yes.
And this was the part that, and there was a lot of talk of having to go back and get, both Dr. Wolf and Andrew Rensselaer. They both had to go in and give their full CVs. And I'm a little bit like, okay. I mean, again, just the differences between the two. I mean, I think, I don't know if it's just me and maybe I'm completely biased, but you look at the two, you look at what the prosecution is giving us, and then you're looking at what the defense is giving us. It's just, it feels like night and day. And
they had full voir dires for both of the ARCA people, but not for the Aperture folks. So Shannon Burgess did not have a full voir dire. They just laid that foundation of his expertise in court, and that was acceptable. So that is also, again, shocking to me that that's something the judge is determining, right?
Well, no, because normally, I mean, at least in California, this is how it works. That if you want to present expert testimony, you bring in your expert. The attorney who's offering the expert will question the expert, and then try to lay the foundation that they are qualified to testify, talk about their education, their training, their experience, whatever. And then the other side has an opportunity to ask questions or cross-examine them. And then you ask the judge to qualify them as an expert. And the judge rules on it and says yes or no. So how is it that one side had to go through that process, but the other side didn't?
Right. Yeah.
The prosecution side didn't have to do that.
That's my understanding from, again, April 1st and a little bit before on of rewatching it. Yeah, no, that Shannon Burgess was, because if he was, this would have easily.
Yeah, I never would have made it.
No way.
And in some ways, this looks worse, I think, right? If they had just voir dired him and then they're like, yeah, this guy doesn't fit, he's gone. I think this helped the defense, because the defense, they were able to so everything he just said becomes, oh, all of this is wrong, or he's lying. I mean, in some ways, it would have been better for him just not to testify, I would think. I don't know if.
Yeah, because you can't take it back. I mean, the testimony's out there. It's permanent.
And he had supposedly found the SD card that nobody had found before in this Lexus and did analysis on that. Like, so it's I'm not a forensic expert in all of the technology, but he had some SD card that had not been discovered in any of the previous investigations that he was bringing to this trial. So that's even more questionable. I could not disentangle what is on the SD card that's unique or specifically different for his testimony. But that's the other part for me, that then if the prosecution wanted whatever that information was in, it wasn't clear, number one, but number two, it was coming from Shannon Burgess, who the defense just impeached I mean, Burgess was red throughout that, like clearly very physically embarrassed as this was happening. So,
yeah. You almost start to feel sorry for the guy. I mean, again, he did it. you start to feel like, ooh, this is painful. Yeah. Painful to watch.
Well, so setting aside their, lack of qualifications, I mean, what did you think about their testimony? I mean, did they make any good points, did you think? Or is it just was everything just overshadowed by this lack of credibility?
So I think that, well, for me, that comes in, but I think part of that is me, again, being a professional with a CV and knowing the consequences of that, but trying to think of what makes one of the things that makes this case so complicated is when we're talking about the triggering events in the Lexus, the different times on the different devices, and what time they think the collision might have happened. And the prosecution even changed their timeline mid-trial, and the judge allowed them to do that. And it's changing it from like 12:31 to 12:32 or something like that. But that minute is really important because it takes Karen would have needed at least 6 minutes on a day with perfect weather to get to John O'Keefe's house. And we know she connects with the Wi-Fi at John O'Keefe's house at 12:36. So the prosecution made the timeline, I think, in the wrong direction. So I'm guessing that's why the defense still argued that they shouldn't be able to do that, because they already had cross-examined witnesses, had sent information to ARCA based on Aperture's timeline, and now we're changing it. So I think a lot of that gets lost. And I think when you watch the paint, if people haven't watched this paint reconstruction video, you just look at it and it's like, my 10-year-old would know that's not, like, I think he could come up with a better way to reconstruct an accident, because it's just doesn't make sense on the surface that shows you anything of value.
Yeah. Because, right, I can put paint on anything and then bang a body part on it in any which way, and paint's going to come off. Like, yeah, that's how that works. Thank you, Welcher. We understand how that works, but you're not telling us anything about the car or how any of this is, and this kind of leads into, his injuries. And there were, it was Dr. Russell and Dr. La Posada who testified for the defense. Who did they have in the prosecution?
The prosecution, let me check my extensive PowerPoint notes. The prosecution had the paramedics that were just talking about the body at the scene.
And what did they testify to, the paramedics?
One, they were claiming that they heard Karen say, I hit him, I hit him, I hit him. But then it was clear from watching the dash cam video, I think the defense did a pretty good job of showing that they couldn't have heard her. And also in their first reports and like, I don't know if it was on their response to the 911 call, they said the guy looked like he'd been in a fight with Mike Tyson. So it was clear that they thought this was a physical altercation, not a car accident. But the paramedics were talking about that. Nope, that's a different person. Their medical examiner is Dr. Scortibella.
Okay. And so what did that person testify to?
So Dr. Scortibella talked about the difference between cause of death and manner of death. Also testified that John O'Keefe's blood alcohol level was 0.28, which is more than 3 times the legal limit. Like that's high, really, really high. Talked about the rib fractures that were consistent. So there were rib fractures on John O'Keefe's body, but they're consistent with life-saving measures, CPR, and I think it's a Lucas machine. I can't remember the name of the machine where they try to do life-saving measures on the scene. Also, Scortibella talked about the head injury, that was the cause of death, and wasn't so sure that hypothermia may have played a role. So indirect, she kind of said it could have, and cross, she admitted it might not have been, because there are these types of ulcers. It got really specific about his pancreas and things. And then there was no grass or debris in his head wound. There was a J-shaped impression on the skull. So where the skull fracture was a J-like shape. And also that John O'Keefe didn't have frostbite and didn't have damage consistent with a pedestrian vehicle accident. So there was nothing on the legs, for example, and no other broken bones.
Yeah, the J-shaped thing in the back of the head, I heard someone talking about how they think that, I guess eventually at some point, they got into the Albert house and saw the basement, and then there's like, weights down, and there's these, hand weights that, if you look at the round side of it and the indentations and where the, like the bars come out, that it kind of looks like a J. And that was one theory that I heard, that, he could have been hit in the head with one of those free weights.
Or maybe he could have someone hit him and he fell back and hit the back of his head.
Yeah, fell on the weight.
That's also possible. So this is the part about this case that I find fascinating. It's like your whole case is this woman intentionally hit this guy with her car, and your expert, your person's like, I don't know, I don't think there is. Yeah. I think there was an accident, and you're just a little bit like, so we're going to keep going with this.
Well, that's the thing. They seem to just keep hiring these people who are not helping them, and their testimony is not helping them. And also, part of police investigation is not just like trying to figure out who did it, but ruling out other possibilities. Which is why the fact that they never ever went into the basement is crazy. Like they never got a search warrant to go inside the house to rule out what was the scene in the house? What was going on? Was there foul play happening inside the house? I mean,
and that's something Alan Jackson talks about a lot. And he brings up, I think he brought this up. Ashley, you probably speak to this better than I can, but in his opening statement and his closing statement, just the fact that if you really just take all of this aside and you think about this, there is a dead man on your lawn. Why isn't anyone rushing to, your sister's in the home right there, like that nobody's rushing into the Albert's home. Nobody is, that these people are first responders. They know CPR. They know it well. These are the first people that you want to knock on the door and say, can you help us? What are you going to do? I mean, just I mean, just the fact that nobody bothered to even knock on the door and ask. And then you have all these people in your front yard and you don't leave your house. You're a first responder. You care. That's the other part.
Yeah. And the police never getting a search warrant. That's just beyond negligent.
Yeah.
It's misconduct. You know.
Well, and when the jury went to do a viewing of 34 Fairview, there was a rock. I don't know if either of you heard of this that showed up.
Yes. Yeah.
Wasn't there the day of the accident. It was on the lawn and it looked like it had like a brown smear on it. And then it disappeared after the jury viewed it. They had to give the jury instructions that rock was not there on the day of the crime because again, who knows if it's just happenstance, something like that showed up. It's very suspicious that it showed up all of a sudden on the lawn. But either way, when he hit his head, he lost 3 liters of blood.
Mm-hmm.
Where's that blood? Like, it should be under his body. It should be frozen there. Or there should be that's a lot of blood.
Well, the other thing too is if she backed up and hit him, how did he get way to the other side?
Yeah.
Like, because really what that meant is she had to have hit him in such a way on his arm where the tail light broke, scraped his arm several times. Then he had to then fall down, fall back, hit his head, and then get up and then
do a
get himself to the other side.
Yeah. Some feat of acrobatics had to have occurred for his body to move that far. But going back to that rock, but hadn't the Alberts, by the time of the trial and the viewing, hadn't they sold the house, or were they still there?
Nope,
so
they sold the house.
They came back, in the middle of the night before. Yeah, they came back in the middle of the night to put a rock over something that they obviously wanted to hide.
Or to explain the J in his head. That's what I thought the rock was for. Like, see, that's how he got the thing on his head, that rock. But it could be, the scary thing is it could be the Alberts, it could be the McCabe's, it could be Proctor, it could be, do you know what I mean?
Brian Higgins.
It could be Brian Higgins. It could be that Yuri. I mean, it could be anybody who had this brilliant idea of doing that.
I have a picture of the rock if you want to see it.
Oh, yeah. Here. This, and everyone who's tuning in, this is why you need to subscribe
on
YouTube and come over to YouTube because Ashley has visuals. Oh, and so it says Albert on it.
Yeah, isn't that weird?
That is very weird. Maybe someone just wanted to honor them. Yeah.
It looks like one of their kids made it for, some holiday.
Arts and crafts.
Yeah.
Huh.
That is weird. And why didn't that appear in any photos or any reports from the crime scene?
That's a good question. I don't know.
Wow.
Okay. So what else? Oh, so we're talking about the arm. So let's talk about Dr. La Posada and Dr. Russell. Dr. Russell testified first.
Mm-hmm.
So do you have something on her? Oh, great. See, look at all these.
Oh, yeah. I still have it shared. Do you want me to take it down? Because I'm kind of just like running through.
No, share it. This is great.
So Dr. Russell... the thing that Dr. Russell added, she added stuff about it being consistent with animal bites. She wasn't allowed to say dog bites. Hank Brennan opened the door somehow. I can't remember exactly how, but there was already a motion that she wasn't during voir dire. She wasn't going to be allowed to mention dog bites specifically or compare them to the dog that the Alberts had. So that was a time where they asked for a mistrial with prejudice too, because Hank Brennan brought up animal DNA in the wounds. But Dr. Russell also talked about an acute grief reaction because Hank Brennan kept asking her if Karen's behavior seemed inappropriate. And she was just stating that people respond differently with grief. And so it's not uncommon for them to even question, like, did I hit them? Did I do this? Am I responsible for that? So I don't think Hank Brennan meant to do that. That was, I think, accident that came out.
Brennan made a lot of mistakes and a lot of, I feel like, rookie mistakes. We can talk about that when we get to that, but that was insane. But Hank Brennan was getting on her because apparently she called the defense and offered to testify because she said, well, I felt like I had this very unique background where she's in her 60s or 70s. She and Dr. La Posada, they were my two favorite because these are women who they have no more F's to give. They are sick of men like Hank Brennan and all these other guys they've been dealing with. And they just were like, no, you're not going to tell me anything. I know what I'm talking about. And she really came in with like, yeah, I volunteered and I told them that I could because I have this expertise and I'm one of the few people in the country that has this certification, this certification, this certification. I mean, she had these 2 or 3 certifications that were very specialized and absolutely she was right. And she testified, no, those are animal wounds.
Yeah.
Well, because they didn't want her to testify that way. That's why they blew her off.
Well, no. She volunteered to testify for the defense, which she did. But Hank Brennan was trying to kind of infer a little bit like that she was some kind of wannabe star, like, don't you want to be involved in this super cool happening case? And so you called them up and said, oh, I can testify for you. And I'll basically saying that she just wanted to be on the witness stand and all of her credentials and all of this other stuff that she's done doesn't matter because she volunteered to do this. And that was his issue. Ashley, do you have anything to add with her?
So her main conclusion is that she thought those are dog bites or animal bites. I do apparently like forensic odontology, which is bite mark reconstruction, which you might see in like CSI things. It's not very reliable for lots of reasons. There aren't good protocols for a lot of them. So that's why she couldn't definitively say like it was whatever the type of German Shepherd. Was it German Shepherd that they had? Maybe
it was a German Shepherd. Yeah. That they couldn't say that or that it was a specific dog, something about bite evidence not being allowed in Massachusetts, but it was consistent with animal bites. So I think that's the big thing. And that was, I think, the first time that the defense asked for a mistrial with prejudice in the case. And then La Posada. Okay. Oh, okay. Yeah. The big thing with La Posada is the head injury that John O'Keefe had because of where it was at and how severe it was, that after sustaining that, he wouldn't have been able to walk or talk after that type of head injury, and would have died within 20 minutes. So might not even have been conscious. So he could not have gotten up and walked that amount of time where there's those steps on the phone of him walking. That couldn't have been after his injury. It couldn't have been him walking because what is it, the Apple Watch data or his phone showing him walking? Mm-hmm. It wouldn't have been possible. That severity of a head injury, you'd be unconscious pretty quickly, definitely not walking or talking because it's right by your brainstem on the back of the head. And so if she had hit him with her car, there's no way he would still be in that exact same spot wherever he landed. Mm-hmm. He would still be there. Yeah, well, he wouldn't. Or that's where they would have found him.
Right. Like he couldn't.
Yeah, he couldn't have gotten up and moved and gone anywhere.
Yeah.
Right.
Yeah, and he had 2 black eyes, which is consistent with, falling and hitting the back of your head.
Yeah, or the blood draining that way. Yeah.
Psych Legal Pop will be back after these messages.
Chicago, 2011. A cop is murdered. Police and prosecutors swear they have the trigger man. He swears he didn't do it. How far will each side go to prove they're right?
Like it's just one bombshell after another, where you're like, what?
The story of a PlayStation, a brain-eating amoeba, and the relentless pursuit of justice. Off Duty, out now. Listen wherever you get your podcasts.
Howdy, howdy, ho, and welcome to Fantasy Fan Fellas. I'm Hayden, producer of the Fantasy Fangirls podcast and your resident lover of all things Sanderson.
And I'm Steven, your bookish internet goofball, but you can call me the Smash Daddy.
And we are currently deep diving Brandon Sanderson's fantasy epic, Mistborn. But here's the catch. Steven here has not read Mistborn before.
That's right, hey. So each week, you'll get my unfiltered, raw reactions to every single chapter.
And along the way, we'll do character deep dives, magic explainers, and Steven will even try to guess what's next. Spoiler alert, he'll be wrong.
Newsflash, I'm never wrong. Episodes come out every Wednesday, and you can find Fantasy Fan Fellas wherever you get your podcasts.
One thing that I really didn't realize was that one of the big differences between trial 1 and trial 2 is that Karen had done, and we covered it here on our show, Body in the Snow, she had made some public statements. And Hank Brennan and the prosecution used these public statements as part of their case. And I've read somewhere in different places that legal experts, analysts, they all say that was not good. It was not that she didn't do herself any favors by doing these documentaries. I think she also did a Dateline, but I feel like the Dateline happened before the first trial.
Yeah.
So I don't know if if Dateline came into the first trial. I don't remember it did, but they definitely used Dateline and the Body in the Snow. Right.
Yeah, wasn't The Body in the Snow also a Dateline production?
I don't know. I know it was on, no, but I feel like it was like a TLC.
It was on Max.
So
okay.
An ID Discovery kind of a thing.
Well, and they started filming that during the first trial.
Yes.
And it was like a documentary of showing the first trial. And, you kind of got a sense watching it that, like, they really thought they were going to win, and that this documentary was going to be, that much better by this victory.
Yeah.
And then, they sort of won, they got a mistrial. It's better than a conviction. But, she said a lot of stuff. And so now all of those public statements are basically like admissions, and admissions can come in. They're not hearsay. And you can also use them to rebut, prior inconsistent statements. So it's really bad. And any attorney would say, don't do that. And I'm not quite sure what her attorneys were thinking by letting her do that documentary.
Yeah.
That's all I could think at the time, too, especially when she opens it with, this is my, maybe she doesn't open it, but at some point early on says, this is my testimony, which then they can clip that and clip anything together. And Brooke, the defense wouldn't be able to bring in just the video. Karen would have to get on the stand, wouldn't she, the defense couldn't just show a fuller length of that clip to put it in context if they wanted to. Cause there's sometimes where she gets cut off and they cut her off midway, but I don't know about rules of evidence if they wouldn't have been she have to get on the stand, or could they just show the full clip?
Well, if she got on the stand, she would have to be willing to testify, or willing to be cross-examined about everything. You can't selectively testify. So they are not going to do that. And as far as putting other clips up to rebut that, I suppose they could, but it's just too slippery of a slope, because then, then they're going to come back with something else. And then you're in a position where, you're having to defend yourself against all this stuff, but you can't testify. So, I think it's just smarter to just leave that alone. The damage was done.
So, yeah, Alan Jackson is a very experienced, smart, Yannetti, these guys are good. So I'm really surprised. So you really think it was hubris or overconfidence that these two guys were like, oh yeah, let's do this. This is all, we're going to wrap all this up. This will be great.
It's all I can think of, because no attorney would ever recommend that or do that. Or, I guess it happens. Obviously if the client they can't help themselves and they make a statement and you can't stop them, then you can't stop them. But they participated in it.
Yeah. Yeah.
They should have stopped. They should have said, no, this is not a good idea. Like, if you're victorious, how about we film all this stuff? And if you're victorious, then we can play it. But maybe they probably didn't own the rights to it. Maybe they had no control over it. Maybe HBO or whoever, Max, whoever had the rights to it, just, they did what they're going to do.
I also wonder, one thought I had was, I don't know if she got paid to do this. And, as we know, I believe as of right now, right, she's out of money. And
they're not getting paid anymore.
They're not getting paid anything. But obviously, Alan Jack, these guys are getting the best PR. I mean, this is how this works. You if they can get Karen Reed off, then my God, that just made their careers and they can just ride on this forever. So I understand why they're not working, but there must be court fees and court costs and other things that you have to pay for that's not the like paying for you have to come up with money for the experts. The experts aren't going to, I mean, maybe some of them said I would do it for free. I got the sense that like Russell would, or some of these other ones, but yeah. And so she had to get money from somewhere, and we know she sold her home. And so I'm wondering if she just felt like she had no other choices.
I don't know. I know there's probably some Karen Reed defense fund, legal defense fund, but yeah, I don't know. That's just too risky.
Yeah.
Even for money or whatever.
So that, many people are concerned about that, that really could be the thing that gets, because, and we talked about this what your feeling is, Ashley, we talked about this in the first trial, is what's so shocking about this case is just, across the board, how much people were drinking, getting into their cars and driving. Because, definitely she is guilty of drunk driving. And she is, you know what I mean? That's not okay. And that all these people were drunk, drinking and driving. And the fact that, how does anyone even testify to anything with their memories and all of that? This has just been muddy from the first moment. But I can imagine if you're maybe sitting there going, well, she made all these statements over here and I have to, it's her mouth. She said it and she was intoxicated and she was, so that might be, everyone keeps talking about reasonable doubt, but that might be enough for someone to go, well, maybe, I don't know how the second degree thing is, I don't know how but I could see someone going, well, I can believe that she did something that was negligent. Maybe the car did not hit him, but some sort of negligence happened and it resulted in him passing away.
Yeah. Well, that's classic vehicular manslaughter, involuntary manslaughter.
Yeah.
And that's the thing. She said in that documentary, I don't remember dropping him off.
Mm-hmm.
Okay. So that concerns me, that I think that right there is enough for involuntary conviction. It's just because, like you said, some people might go, there's a lot of reasonable doubt and there's a lot of shady stuff, whatever. But out of her own mouth, she said, I didn't remember dropping him off that night. Mm-hmm. That's an admission.
Yeah. So
the drinking and everything.
Well, they did have people to support her dropping him off, though. Those people in a Ford F-150 that saw Karen's dome light on, and just her, and John wasn't in the car. But from a memory perspective, as a memory researcher, none of them have good memories. The fact that Jen McCabe any of them would say with certainty what happened that night before, even that morning, their blood alcohol levels still had to be very, very high.
Yeah, they all had these very precise timelines. I remember that they were very clear about this happened at this time and this happened at this time. So when you're drinking, you don't know what time it is. Mm-hmm. When you're drinking that heavily and it's late at night, you don't know what time it is. You don't know that someone arrived at your house at 1:30 and suddenly everybody remembers they arrived at 1:30. What was that? Colin Albert, that whole thing. They were trying to give him some kind of alibi for something. And, it's just, it defies logic, honestly.
Yeah.
Well, and I think the defense this time with Carrie Roberts bringing up that that group chat, because Carrie Roberts and Jen McCabe also talked with each other after the event to see if their timelines added up, which is also bizarre. But they had shown Carrie, I don't know if she just hadn't seen it before this, but the Jen McCabe texts about watching Carrie's testimony and loving it and being in the room when Carrie was being interviewed by police officers, and Jen McCabe's texting Matt McCabe, and I don't know if the Alberts are on there or not.
Yeah. No, I think they were, because that's one of the, another something that's different than the first trial is, and this did not help the Commonwealth at all, was more time went by. So now we can see more stuff. They have more time to, and they found a whole text chain of a group text with the McCabes and the Alberts. And yeah, I mean, every little step of everything was, what was it? Proctor's sister or wife was texting one of them and saying, oh, we need to get you a gift or something. I mean, it was just, all of it was, you know, so shady. And just the number of, I mean, you know, we could spend hours just talking about Jen McCabe's testimony, but I mean, the fact that just the deleting of all of these messages is so shady, so shady. I mean, it's, and the butt dials, again, we've talked about butt dials, and yes, you can butt dial, but you only butt dial once. Nobody consistently butt dials the same person and butt dials them for 3 to 4 minutes at a time.
And they butt dial back in between.
Yes.
Perfect, you know, synchronicity there.
Yeah. So, do you have anything else to say about anything about her public statements?
I don't. I think that speaks for itself.
So another thing was, I want to talk a little bit about the prosecution and sort of the differences. So they replaced Adam Lawley, who was really kind of a little boring. And, you know, for someone, I mean, if you're a trial attorney, you have to have a presence. I mean, both sides, right? I mean, trial attorneys need to have a certain charisma or certain like something. And Adam Lawley was like, falling asleep. And so he wasn't very effective. And so they're like, so you're the Commonwealth. Who are you going to bring in? Another weaselly little numbnut. You know, Hank Brennan. This guy, I'm like, this guy's even weaselier than the last guy. Do you know what I mean? It's like, why not bring a woman or, right? Like someone with some charisma, someone with something. There's, I guess, apparently, because
maybe no one wants to do this case.
Well, Hank Brennan is a defense attorney. He's famous or well known for defending James Whitey Bulger. That's 10 years ago. And so, and I guess they paid him to come in as a special prosecutor. And apparently the legal analysis that I've been looking at says that maybe he wasn't the best choice because he thinks like a defense attorney. He's got that defense attorney mentality, and a lot of the things that he was focusing on and doing really wasn't what you should be focusing on when you're a prosecutor. And he did, I mean, you know, he made many mistakes. He allowed way too many, the testimony. I mean, even asking Dr. Russell that question about, you know, trauma, like she just explained all of the, I hit him, like right there. Dr. Russell did. And some of the questions, the guy from ARCA about like how after the first trial, after he testified, he had a ham sandwich with the defense team, you know, before he got on his plane. And Hank's trying to make that into something much bigger than it really is.
Oh, no.
Like, and you had a ham sandwich with them. And how did that ham sandwich taste? And okay, well, don't you think that's suspect? I mean, it was just weird. So, Ashley, what was your take on Hank Brennan?
Can you hear me okay? It's saying, okay. I don't know if I bounced out or not. So from someone in psychology, like coming and someone who teaches people, I think the charisma, like what makes good teachers are people that can get in the head of a jury and explain something in detail and also know those questions to ask and not ask. I always think that the defense attorneys that come from prosecution make really good defense attorneys. Maybe this is just the only example that's coming to my head because it's recent, but maybe it just doesn't work very well. The reverse going defense.
No, it
prosecution.
doesn't.
Yeah.
But he was very, hostile. And I think I'm not a lawyer, but I think you just have to be, but knowing how people view other people, you can't be so hostile to everyone. Like, you really have to pick and choose when you're going to raise your voice, or where you're going to like what you're going to be punchy about. Because if you're at 100 the whole time, the jury's just going to tune out and not know what to pay attention to. So,
yeah. Well, he also, I mean, he had some moments in there that you're putting your hand, you're just like, oh my God. So they had the snowplow driver, this guy named Lucky, testify about going through, and basically Lucky testifies he circled the in front of 34 Fairview many times that night and didn't see any. And it's not a huge lawn, it's a small lawn, and his big headlights. And he said, yeah, I looked this way, I looked that way, and there was nothing on the lawn. Nothing was on the lawn. Nothing, nobody. And so Hank comes on and he wants to poke holes in his testimony by saying that Lucky is enamored with the trial because he follows Turtle Boy's blog or something, or Turtle Boy talked about him or reached out to him. And there was something in there that Hank was trying to make Lucky look like he was just testifying and saying these things because he wants to be famous, or he wants to, So Lucky's responding to him and he says, well, I'll be really honest with you. I wasn't paying attention to social media at the time. My wife had just passed away and I was really focusing on other things. I wasn't paying attention to what this guy was saying about me. And Hank's like, okay, well, sorry for your loss, but didn't you? So it was just stuff like that you're, boy.
Tone deaf.
He mentioned like, oh, Lucky, you didn't follow protocol, because Lucky mentioned I went through the first time, and then I think it's the Jeep. There's a car that the flag.
Yeah, there's this like Ford Explorer,
right? That
on the street.
That Lucky sees, and again, I don't know if people from living in a climate where get a lot of snow and those sorts of things, and knowing what the snow plows look like and how they behave, they would typically call a car in like that, but they are constantly looking to make sure they're not hitting people or animals or things. So he would be very attentive if something was there. And Hank Brennan pointing out, well, you didn't follow protocol and call in that vehicle. He said, well, yeah, I didn't, because I knew it was police officer's home. So I was just being courteous, I guess. Which also was not a great line of questioning from Hank Brennan, because now you're showing that Lucky's I don't know if it's pro-police or just like the family or what. But.
Well, yeah, he said the same thing in the first trial. He said, that he didn't call it in because he knew it's the Alberts' house and he knows them, and he what are you going to do? Like,
yeah. Which makes, I think that I would assume that snowplow drivers probably do that a lot, right? I mean, everyone call in. You don't want to
people.
Yeah, you're like, oh, I'll get the snow when the car is gone. Like,
well, they definitely tow people a lot. So if you're in one of those places with the snow, like constantly, you would get towed. Like I'm not in Massachusetts, I'm in Iowa, but you do not park on these places where snowplow. They will tow you. So it is odd that he would not have called that in from that perspective. Like if I was a juror not knowing that, oh, it's because it was a police officer and he testified to that. I personally haven't had my car ever towed. I know a lot of people that have, because they just, especially out of college students that are in the wrong, because they're such big machines and they have to get the snow, having cars are too difficult to maneuver around. That's a long snowplow thing. Sorry. That's just
and then the other big thing was the way in which Hank presented the information. Apparently Lolly went more chronological and Hank had his own way of doing it. I'm not quite sure exactly what the strategy was, but it was like bringing things in at different times to kind of constantly be reminding people of things. Again, I didn't really see, again, I think we're back to maybe that works in defense more than it really works in prosecution. I didn't notice that it was radically different, but I wasn't watching it as closely as you, Ashley. So did you notice how this different way of doing it that Brennan?
I noticed his demeanor was different. The timeline changing is concerning that they changed timeline midstream, which again, if I'm a juror, I would think that I'd be like, why are we changing the timeline at this critical piece? But I'm looking through like who they called in what order. They started with, who did they start with? They started with Timothy Nuttall, who's one of the paramedic responders. Then they went to Carrie Roberts. So they jumped a little bit. Then they went to Peggy O'Keefe. Why have her? She just hates Karen Reed. And I mean, I don't know why.
Well, I think she impeached her on something that Karen said that Peggy had said in the first.
About what she said to her in the kitchen.
Yeah. She came and testified and said, I was never in the kitchen with her or whatever she said.
Okay. So that's why she was there.
Yeah.
But yeah.
But a lot of times too, with trials, you have to realize like there was so many witnesses. Sometimes you have to call people out of order and you have to get them in when they can. And so that's why it might not make sense, the order of it. I mean, you try to present it in a chronological order, but sometimes you just have to take what you can get.
Yeah.
Because they must have had dozens of witnesses and
34, I think.
Yeah.
So no, that's very true. And then with the defense, obviously it was still Alan Jackson and Yannetti. They brought in Alessi, who I did not know who Alessi was, but apparently he's a very prominent New York attorney. He came in and he's part of it. And also this woman, Victoria George, who was an alternate jury on the first trial. So she never deliberated. So she was able to join the defense. And the other big thing is just their strategy changed. I think instead of because I think they realized that us trying to prove that Brian Higgins did it or Colin Albert did it or someone in that house did it, that's too hard, that we're just going to, that their approach was more of this, poking holes in everything and showing, it feels like they're showing a conspiracy of something going on, but they weren't spelling it out so much. Is that?
Yeah. They definitely always, well, again, I didn't watch the second trial, but I don't think that this has changed. That, yeah, their contention is she was framed. She's being framed. And by pointing out all of the suspicious things that all of these other people are doing and, all their craziness with their phones and their timelines and their this and their that. Why is everyone so, not coming into the house, not going out of the house, not, all of it, it's like you figure it out, jury, like this. And I guess is this thing with Brian Higgins and the timeline, this is new to this trial, correct? Where they have him on video at 1:30 a.m., which is the time when Karen Reed got to John O'Keefe's house. He is at the Canton Police Department at the station, taking things, bringing things in, or what is he doing there?
Yeah, so this was a video that they found Michael Proctor had, or just, I don't know, discovered after the first trial. But yeah, so Karen Reed connects to John O'Keefe's Wi-Fi at 12:36 a.m. And when all those butt dials are happening, it lines up with the timeline of Brian Higgins being at the police station. And the first trial, we didn't have the video of what he was doing there. But the first trial, he said he wasn't talking to anybody on the phone. He just went there to move cars around because it was snowing, which is a very weird thing to do, but I don't know. But this time we had a key swipe. So we knew he was at the police department because there was a key swipe, but now we have a video of him walking around. You can see him talking on the phone because his face gets illuminated, and that lines up with about the time these phone calls are happening. And then he's moving items in some sort of duffel bag. So
that's
really
not shady at all. Moving items in a duffel bag?
Who knows what it is? Yeah. I don't know what he could have been doing there, but I don't know. I'm trying to think of if this was an accident, I don't think anybody intentionally, if it is the case that he was killed in the Albert's home, I don't think personally anybody was intentionally trying to harm him. I don't think or kill him at least. So maybe what this video is, they didn't bring this out at trial, but I'm just trying to think about what could he be doing? And maybe that was before they thought about Karen having possibly hit him. And so they were maybe grabbing evidence to try to explain it some other way. I don't know. I don't know what.
Yeah.
And if he's at the Canton Police Department at 1:30, wouldn't he have stepped right over John O'Keefe's body?
Yeah.
Leaving the Albert House?
Yeah.
Right.
Yeah.
Right.
Very good point. Very good point. But that lawn is so massive. That's the other thing, right? There's that people realizing like this front lawn of theirs is not that big that anybody could spot a 6 foot, 200-pound guy very easily.
Well, and also police officers are usually pretty observant and, aware of their surroundings and looking around, looking for things. So anyway.
Yes. All right, let's talk about, I want to talk about the jury instructions and then I want to talk a little bit about if we have some predictions or thoughts at the end. So before we started recording, Ashley, you have a copy of the jury instructions. Though the last time you shared, I think we had some technical problems, so we might not do that. But just from looking at it, it's very confusing.
It's actually the verdict slip. So
the verdict slip, sorry.
So it's what the jury fills out after they're finished deliberating. And jury instructions, verdict slips, very, very, very confusing in every case. Juries always struggle with these. And it's very hard to make clear. And this came up in the last trial. I remember Alan Jackson was arguing for changes being made because it is confusing. And we saw that when the jury couldn't come to a decision, they were confused. They weren't really able to articulate to the judge that they had apparently come up with a verdict on 2 of the 3 counts, but were hung on the 3rd count. The judge misunderstood what they were saying. It's all very, very confusing. So this verdict slip, the first thing you can check off is basically not guilty. And then there's 2, 3, and 4, which are the 3 different charges that go in like descending order or ascending order. Descending order of seriousness. But there's no instructions like it just has a place to check guilty on all of them. Like guilty, 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 almost as if you have to choose one. You have to choose one. There's no instruction along the lines of, you can choose guilty or not guilty. And if you choose not guilty, then you can go on to the next one, or you know what I mean? There's no instruction. And apparently the judge did not allow any changes, correct?
No, and they argued for that today again. And that was a ruling that came out earlier this morning that she wasn't going to change it because it was consistent with Massachusetts law. It's in the jury instructions, but because I just think when you don't have it on that form, like you're saying, Brooke, it's confusing. And it has numbers next to it. So like 1, let me double check. I think so 1 is not guilty. 2 with like a under thing is guilty of offense as charged. 3 is guilty of lesser offense. So I think the numbering also is confusing because we're used to taking tests where you answer everything yes or no. And so I think that would be confusing as a jury member.
Well, I have heard, there are people reporting on who are in the courtroom that will report on sort of the jury's reactions to things. And so what I've heard from many people is that apparently this jury is much younger than the last jury, that there are a lot more people in their 20s and 30s, that they are taking notes, copious notes, that there's some real note takers. And that definitely, they appreciated the ARCA testimony and were writing a lot of notes. And then when stuff came up about like Welcher was not terribly popular, like Burgess, I think I remember one person saying like the minute all that stuff came out about Burgess, they many of them put their pen down and were like, okay, so I just kind of delete this guy. Right. So I do think that's interesting because, and this is what makes me, if we go right into the predictions, My prediction is that she'll be acquitted, though now that we've talked about this a little bit more, I'm a little nervous. I don't know. But that I felt like having this younger jury, I think, has helped her a lot. Just understanding, I think, a lot more of the technical stuff, the phone stuff, this thing happening, that thing happening, butt dials and all this other kind of stuff. I think they can sort of see through it. I feel like, maybe. I could be wrong, but I don't know what you all think.
Do you want to go first? Second, I guess.
I don't know if I really have a prediction. There's a part of me that thinks, just the fact that she was drunk driving and couldn't remember what happened, that's kind of automatically a involuntary manslaughter. And that was the charge that the first jury hung on.
Mm-hmm.
But if the jury does believe all of this forensic evidence that, he was not hit by a car, then, then she could be acquitted. And, I think it almost seems like in the first trial, the sort of framing and corruption maybe took center stage more than this trial. And that this trial, the defense really drilled down into the forensics and got very serious about it. And maybe that's a better bet than reasonable doubt.
Yeah.
Because people have trouble with reasonable doubt sometimes. And so she could be acquitted on reasonable doubt. She could be acquitted on the pure forensic stuff. So that's not much of a prediction, but
no, that's interesting.
That's
and
I'm thinking.
Go ahead, Ashley, because I also want to get a prediction on are they going to retry her if it's a hung jury? But go ahead.
I think it's going to be a hung jury again. I just think it's too confusing. I mean, explaining so this case, as I mentioned earlier, is really helpful to show my students in the fall about reasonable doubt and beyond a reasonable doubt versus clear and convincing evidence versus preponderance of the evidence. Like mathematically, where does that lie? And people argue about beyond a reasonable doubt. Is it 90%? Is it 99%? Like, where's that at? This has a lot of reasonable doubt, but I just think it's too confusing. I think the timelines are confusing. My one question for Brooke, I'm not sure. So they didn't poll the jury last time. One, I don't know if you can poll juries for a mistrial or not.
Yeah, you can.
And two, so if you can poll them, can they have a split verdict where they do say acquit, and then they're hung on a third? Or would it just be a mistrial because they couldn't decide on all three?
Well, no, I think if the judge had polled them or if one of the attorneys had asked them to be polled, I think what would have happened was that the judge could have entered the not guilty verdicts on the two, and then it would just be a mistrial on the one.
Yeah, because I'm not a lawyer, but teaching on these concepts, I know that is it's something you want to know. You want to hear what they're thinking and for them to say it individually too. So that was
part of the
bizarre.
Part of the problem was that the jury didn't really speak. The foreperson who was writing these notes to the judge wasn't explaining what was happening. And it was just bad communication all around. And the judge, she sent them back a couple times to keep deliberating. And then she just let it all go. And the attorneys didn't think to do it. I think it was just a very confusing moment. But, they did a motion after that to try to get those two charges, that she was acquitted.
Right.
And the court made a big deal about how at any time the attorneys could have asked for it in court and they didn't do it. So it made it sound like under Massachusetts law, if they had requested it and there was a clear record and they would have gotten it. And that makes sense because it has to be done in court right then where you're asking each person. You can't then a couple people call your office and say, we were going to acquit her on those two. I mean, that just doesn't really cut it. So
Yeah.
I get it. But again, I can't believe that, someone didn't think of that in the moment.
Even the judge, like the Lori Vallow trial that just ended, the judge was like, we're going to poll. Like neither side had asked for it, but the judge just said, like when it's a high profile case, I don't know why the judge didn't say, let's get it. I don't know.
Well, this judge is very questionable. Very, very questionable.
Yeah. So what was do you have a prediction, Ashley?
I think
you said mistrial.
You said mistrial. Yeah.
Right.
I mean, I think they'll pull them. So maybe they'll do the same thing they did last time and acquit on a couple and be hung on one. But I think they're going to be hung on one or more, especially with how long it's taken. I mean, the way that the jury instructions went out, they went with a evidence style explanation. So they told them don't do a straw poll of like who thinks guilty and not guilty, but go through the evidence. So usually that does mean longer juror deliberations. So do longer trials generally. But that also, the longer they're in there, the more that also could indicate that they're stuck. So,
I feel like more and more as we talk about it, I feel like it's going to be a hung jury. And I don't think they're going to retry her. I think, or I think that they're going to be, because people are pissed of how much money and time and money was put into the first one. And now numbers are coming out, 400,000 for this, this person. And so I do wonder if they do try her again, is this going to be a huge uproar? I mean, I'm not paying taxes in Massachusetts, but if I was part of that community, I would be pissed.
Well, even beyond the money, it's like you got 2 bites at the apple. Like, how many more do you get? The defendant, if the defendant has no say in whether or not they get retried, it just doesn't seem. It seems like it's enough. And especially if it's unpopular opinion with the public.
Yeah.
Do we know, like, Brooke, I don't know if you would know this, like a case that is like the most retrials that there's been for a case? Because I'm trying to think in my head, not a lawyer, like 3 seems excessive, but I don't know. Are there ones that are more than that they retry?
In modern times, I can't think of any, but we were just talking about this test yesterday. And of course, I still can't remember the name of the person, but there was this guy who was a Fatty Arbuckle.
Oh, yes, that's
remember
right.
That
this was a long time ago.
A long time ago, where he was accused of some kind of sexual assault. Anyway, they got him on the 4th try. And
he was very high profile. He was a famous actor.
He was an actor. He's very popular. These juries just kind of refused to convict him. They didn't believe it. I don't know how strong the evidence was, but I mean, in modern times, I can't think. I mean, obviously, we only know about high profile cases, but I think 2. I think 3 at the most. I mean, my goodness, I don't know.
Oof, boy. Well, we've said a lot. Hopefully, we made some sense of some things, talked about a few things, but I have been watching this on TikTok, like I said, and I was like, I have to talk about this, sort of the differences. And it's a fascinating case. I mean, I think much like any of these other cases of Scott Peterson and O.J. Simpson, like these cases where it's very complex and there's many, many issues, and you can see, I mean, again, this is a little different than the O.J. and some of these other, but like you can see multiple sides, because as much as I will admit I am pro Karen Reed, I can at the same time go, yeah, you were driving drunk and you can't remember anything. And that there is that other part of it too. As much as you want to be able to say, oh, let's just let her go, she's not completely innocent.
And there are victims, and that's another thing that the district attorney has to take into account when they, maybe they don't want to retry a case again, but, the victim's family is counting on you to get, quote unquote justice, whatever that means, for their loved one who's no longer here. And, you feel a duty to the community and all kinds. It's very complicated. And look, any case that gets to trial, especially, criminal cases, there's always very interesting things going on both sides. And that's what makes it so interesting to watch. Because if it was cut and dry, this case would have, you take a plea deal or whatever.
Yeah.
You don't go this far and get this far if there's not serious, evidence on both sides. So,
yeah. Well, thank you so much, Ashley, for joining us. Is there anything that you want to plug or mention? Happy to be here.
happy to be here. I love talking about this stuff. It's obviously, I have a PhD. We don't get paid a lot of money for that job. I just enjoy talking about it and chatting with both of you about it. Nothing to plug other than if you haven't taken a class in psychology and forensic or legal psychology, that'd be a good thing for folks to do just to get a sense of how the courtroom works.
That's
and I hope you'll come back
right on
after this verdict and we can check in and a debrief and come back and talk with us again about another case. Because we've really enjoyed talking to you and getting your perspective.
Yeah.
Thank you. I've enjoyed talking to you both too. Thank you so much.
Absolutely. And thank you everyone for tuning in. We're here on YouTube, so go check us out on YouTube and other social media platforms. We have a Patreon, so go check out our Patreon. Other ways to support us, give us a 5-star rating and review, subscribe to the show so you get all the downloads every single time. And I think that is it. Thank you so much, everyone.
Thanks.
Bye.
Thanks, Ashley. Bye.
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 This message comes from Jackson. Taxes aren't something you can only think about once a year. With investments, planning for tax day is year-round. Fortunately, Jackson offers tax-efficient products. Visit jackson.com for more information on how our products can make your tax bill a little bit less painful. Jackson is short for Jackson Financial Incorporated, Jackson National Life Insurance Company, Lansing, Michigan, and Jackson National Life Insurance Company of New York, Purchase, New York.
Howdy, howdy, ho, and welcome to Fantasy Fan Fellas. I'm Hayden, producer of the Fantasy Fangirls podcast and your resident lover of all things Sanderson.
And I'm Steven, your bookish internet goofball, but you can call me the Smash Daddy.
And we are currently deep diving Brandon Sanderson's fantasy epic, Mistborn. But here's the catch. Steven here has not read Mistborn before.
That's right, hey. So each week, you'll get my unfiltered, raw reactions to every single chapter.
And along the way, we'll do character deep dives, magic explainers, and Steven will even try to guess what's next. Spoiler alert, he'll be wrong.
Newsflash, I'm never wrong. Episodes come out every Wednesday, and you can find Fantasy Fan Fellas wherever you get your podcasts.
Does your day move faster than you can keep up? With new Gatorade Lower Sugar, my family and I can stay at the top of our game. No artificial flavors, sweeteners, or colors. 75% less sugar, and all the electrolytes of regular Gatorade. Now available nationwide.